The summary of the response of Lagos State government is that it has a pending appeal against the case of Ebun-Olu Adegboro Esquire versus Attorney General of the Federation and others. Suit number FHCL is supplied, delivered by the Federal High Court on 27th March 2014. The basis for this argument is that the records of appeal at the Court of Appeal on 11th November 2014 and what was struck out in the Court of Appeal ruling of 9th October 2017 in quote was the application and not the appeal, as there's a distinction, according to them, between striking out an application and striking out an appeal. Mr. Moyo Onigbanjo San, the Attorney General of Lagos State, couldn't have misstated the law more violently or pressed it into the service of injustice and governmental fraudulence if he had originally set out to do so in the process of defending Lagos State government. The law, as we know it, requires an appellant to cause the registrar or the lower court when you are appealing. When you want to appeal, the law requires an appellant to cause the registrar of the lower court to compile and transmit the records of appeal within 60 days after the filing of the notice of appeal, or to do so himself within 30 days if the registrar failed to do so at the expiration of the 60 days. Kindly see Orders 8, Rules 1 and 4, Court of Appeal Rules 2021. The appellant may apply under Order 6, Rule 9(1), Court of Appeal Rule 2021 for the extension of time if he failed to comply and transmit the records of appeal within the prescribed time. The Lagos State government availed itself of the window for extension of time under the foregoing provision of the Court of Appeal rules when it filed an application for extension of time within which to compile and transmit the records of appeal at the Court of Appeal on the 11th November 2014. However, the Lagos State government slept on its privilege under the law when it abandoned the application and the appeal by extension by not appearing in court on the day the application was to be heard. I mean, they've done what they are supposed to do, but the motion or the application was not going to move itself. The lawyer must be there. I mean, you are the one who is complaining and you are begging for to be accommodated despite your tardiness. But you have to move it. They didn't do that because they were not there to move the application. The Court of Appeal struck out the application and the appeal. In the words of the Court of Appeal, and we quote respectfully, since applicant is aware of today's date and is not in court, we take it that the applicant is not diligent in the prosecution of his appeal. Hence, it is struck out, number deleted. It is important that there cannot be a competent appeal without a competent record of appeal. It is in Garuba versus Umwani 2012 LPELR 9841 Court of Appeal. It was held thus by Order 8, Rule 18 of this court's rule, where there is a failure to compile and transmit competent records of appeal, the appeal may be dismissed. See also the case of Nigerian Navy versus Labinjo 2012 17 Nigeria Weekly Law Report Part 1328 page 56. Therefore, the government of Lagos State has hit a brick wall on its matter and cannot take any further action in relation to the matter. The position of a record of appeal is germane in an appellate court process. This is so much so that absence of record of appeal or incompetent record of appeal clearly robs the court of competence to determine an appeal. According to the Court of Appeal in Kilawa against Alchingi Ananda 2015 LPLR 41625 Court of Appeal said the issue of competence of the record of appeal raises in a very frontal way the issue of the jurisdictional competence of this court to hear and determine this appeal on the merit. It is important to highlight that the Court of Appeal held, quote, the number deleted. It means only one thing, that the appeal number has been struck out. This is the only reasonable interpretation to reach, as an application brought under a substantive appeal cannot have a number different from the appeal number. There can only be one number in an appeal. This is so as the Court of Appeal had held in Diamond Bank versus Ama Efule, 2018 LPLR 50855. The Court of Appeal said that even a cross appeal and main appeal bear the same appeal number. It should be noted that the Court of Appeal dismissed the application and the appeal of the ground of lack of diligent prosecution. This want of diligent prosecution in the prosecution of the appeal by the Lagos State government has made its position so incurably bad to the extent that the appeal cannot be relisted pursuant to Order 8 Rule 18 sub 3 Court of Appeal rules. This is in view of the express provision that an application for relisting of an appeal can only be filed within 7 days of the striking out order. Now, you are, even when you are not there to move your application, and the application does not have a life of its own, you are still given 7 days. You can still come back, cook up 1 or 2 excuses, and the Court of Appeal are very committed to the ideas of fair hearing and justice, and you to preserve your right of constitutional right of appeal will still have allowed you. But did they do that? This is also in tandem with the decision of the Supreme Court in the case of Governor of Zamfara State and others versus Yalangi and others, 2012 LPLR 9715 Supreme Court, which is to the effect that such provision cannot remedy an appeal which is dismissed for lack of diligent prosecution. If the Lagos State government felt aggrieved by the 9th October 2017 ruling, remember now, it took them 3 years. 2014 thing was struck out. They came back and it took 3 years, 2017, and before it was eventually struck out because they were not around to pursue their application to get relisted. They struck out his application appeal. He still had the option of challenging the ruling of the court and having set aside his order by bringing an application pursuant to Order 6 Rule 10 Court of Appeal rules, as you have said. This can only be done within 14 days after the ruling. Again, this was not done. At least effective record of appeal irredeemable, and the appeal still born. The state government are continuing to parade a non-existing appeal. This is Jankara practice. Lagos State government is doing Jankara, abuse their powers as executive, insult the judiciary, extort money from people by saying, oh, we have a pending appeal. Which appeal? They are continuing to parade a non-existing appeal as a basis for flouting the judgment of a court of competent jurisdiction. It is pertinent to note that the Lagos State government claimed that in a statement that the Federal High Court did not specifically or expressly grant the injunction sought in the matter. This is what the Honorable Attorney General and Commissioner for Justice Lagos State, Moyosoro Onigbanjo Esquire, SEN, was saying about 10 days ago. If we are to accept this position as correct, then the question will be, what orders did the government of Lagos State was then seeking to stay when it applied for stay of execution of the judgment of the Federal High Court? Let me take that again. The Attorney General Onigbanjo SN claimed that the order of the Federal High Court did not specifically or expressly grant the injunction sought. Now the question is that then, what are you appealing? No. If you say according to you, there was nothing granted, there was nothing expressly granted, then why did you go to Court of Appeal? You see, this is trying to be clever by half and speaking from 2 sides of the mouth, approbating and reprobating, and this will not be allowed. If we are to accept this position as correct, I reiterate, then the question will be, what orders did the government of Lagos State seek to stay when it applied for stay of execution of the judgment of the Federal High Court? Only the learned Attorney General, very learned Attorney General, and government of Lagos State can answer this question. Based on the foregoing, we reiterate our position that the collection of tolls on the toll gate is illegal, and because of the substantive judgment of the subject matter on the subject of the substantive judgment of Federal High Court on the subject, we hereby place the Lekki Concession Company, otherwise known as LCC, established as being complicit in the Lekki massacre. The owners of LCC, disclosed and undisclosed, the Nigerian police and the Nigerian army, on clear and unambiguous notice that we shall not be paying any toll on the Lekki Ikoyi Link bridge. It is an illegality to pay any toll. It's an illegality for Lagos State government to set up machinery to be collecting toll. You lost a case at the High Court. You refused to appeal it. And when it was brought to our attention, you said, no, we appealed. No, they struck it out. It was an application for relisting that was struck out, not the appeal. And we are saying the foundation of your appeal does not exist. Your records have not been transmitted. You refused, failed, neglected, and abandoned your appeal. And you are talking and saying that you have an appeal. If you mean why you have lost. If you're a law-abiding, constitution-guided, constitutional-respecting government, you have your head in shame, and you don't want to go ahead and be collecting any toll. The LCC and Lagos State government are to also know that we shall be demanding an account of the monies, you see, illegally and fraudulently extorted from the residents of Lekki and other users of bridge since its appeal was thrown out. We are serving notice here, and we are serving notice here for them to know that all the money that has been collecting after the appeal has been thrown out. They will have to account for it. It's illegal money. It's illegal money. It's an act of executive lawlessness, rascality. Even the least recommendation of the panel, which is to rename the Tollgate, ENDSARS Tollgate, have not been done by the state. Abi, is it the federal government that will come and do it for them again? Because they have been hiding under the federal government not to do what they are supposed to do. We are calling for accountability. Not to even talk about the major ones like admitting and apologizing to the citizens for the massacre, identifying and prosecuting all officers involved, compensation of the victims and others. Yet they can do countless of meetings, press conferences and others just to open an illegal tolling location where the blood of innocent citizens was spilled. Nigerians say a very big no to that.
No.
The 86 pages evidence provided by Sarah Ibrahim alone indicted the Lagos State and the federal government on commissioners crime against humanity. Was there a massacre at Lekki Tollgate on 20th October 20?
Yes.
Yes. Let me repeat. Was there a massacre? As investigated, as found out by a panel set up by the Lagos State government, was there a massacre at Lekki Tollgate on 20th October 2020?
Yes.
Have you gotten justice?
No.
Were there massacres in other parts of Lagos and Nigeria on October 2020?
Yes.
Have you gotten justice?
No.
The government of today, led by Muhammadu Buhari, have seriously failed the people. In fact, it seems like the government of today takes delight in taunting Nigerians. While the Minister of Education is purchasing 100 million naira form and refusing to step down. Despite presidential directive, ASU is on strike. Insecurity is raging all over the country, including the Abuja, the FCT, where citizens are constantly being kidnapped. Citizens must rise up and play the police not like the way they have been doing it for the past years, but in a way that will set Nigerians from all their oppressors. And the way to do it is accountable politics. Citizens must recognize their status as citizens. Citizens must not collaborate, must not cooperate with the oppressors, must not yield submission with oppressors. You must demand for justice. The democracy itself needs to be fought for and needs to be protected. You can't leave governance to governors. You can't leave governance to presidents. You can't leave governance to House of Members of our parliament. You can't leave government to chairman of local governments because they are a crop of wicked elite, exploitative. These people do not care for our people. They are worse than even the imperialists and the colonialists because they have every reason to be patriotic. But they are really against the people of Nigeria. And they have been doing that and getting away with it because the people do not rise up to against them. We demand justice for ENDSARS victims. We demand rehabilitation of the maimed and the wounded. We demand immediate release of fear and open trial of those still in prison because of their participation in the protest.
Yes.
We demand full implementation of the Judicial Panel of Inquiries Lagos Recommendations Report. Yeah. We stay no to operation of the Lekki Tollgate, Ikoyi Link Bridge, Tollgate, The Lekki Tollgate itself should be made a national monument as recommended by the judicial panel. All these we demand and we are standing by it. Aluta.
No justice, no toll.